the president the power to do away with this special arrangement. The compromise. So, my lord, one cannot search for too much logic. This was the compromise form. And we must therefore, my lord, the safest thing for a court, in my very respectful submission, as a assembly, then he may. And instead say the president may abrogate this article, provided if he gets a recommendation from the Constituent Assembly. Which there is one, you must get the recommendation. I'm going to deal, Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal it separately. But the historical material available to a court, and we have, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3 that if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. Now, if one looks at it that way, the whole thing falls in place. We kept, the framers of the Constitution kept with the president the power to do away with this special arrangement. History bears testimony to the foresight and wisdom of those, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because the historical perspective of 370 is very important. The troubled relations. While there's always was a hope that the relations with the neighboring country would be on good terms, the history of Kashmir did give rise to apprehensions. And the lordship has seen all the material. So border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in sub-article 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. and a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And my lord, the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. Things will settle down. Don't agree to anything special for Kashmir. The other was the other extreme, saying if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So, my lord, one cannot search for too much logic. This was the compromise form. And we must therefore, my lord, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation of such provisions. And such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political as in its constitutional sense. The court has always said you must give it the widest possible meaning. So we have had, my lord, these two formats. And that is why we come back to why did the framers of the Constitution not say that if the president receives a recommendation from the Constituent Assembly, then he may. And instead say the president may abrogate this article, provided if he gets a recommendation from the Constituent Assembly. Which there is one, you must get the recommendation, otherwise. Now, my lord, this was also made.
Just 1 minute.
I'm sorry. Yes. Can your lordship hear me, my lord?
Yes, we can hear you now.
Yes. Finally, my lord, look at one important nuance of this article.
Yes.
In subclause D of clause B, such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the present by order specifies. So, power to the president to apply or disapply provisions of the Constitution or apply them with modifications. And this does not require unlike B1, that is the spread in the list, the concurrence is not called for.